Well, good afternoon, everybody. My name is Sandy Chen, and welcome to the Samfiru Tumarkin Live Employment Law Show. I think we're on Facebook, we're on Twitter and LinkedIn. I will be here for the next half an hour or so, answering any and all questions to do with employment law. I work at our firm's Vancouver office. So if you're from BC, that's great. If you're from another province, I'll try my best to answer your questions. But please feel free to ask anything and everything about issues to do with your employment. If you're having issues at work with your boss, if you're having, issues of bullying, harassment, if you've been let go as part of all these mass layoffs recently, if you've got a new employment contract that you have some questions about, some terms in there, please put in your question to the text box in front of you, and I will read them out in the order I get them. I can't see anybody, but hopefully everybody can see and hear me. But I did have some topics I wanted to chat about today, but I will put priority to any questions that may arise. And one of the topics which seems more prevalent these days is these mass layoffs that are happening. We've seen companies like Rogers and Shaw. We've seen companies like a lot of the tech companies, Shopify last year. Some of the banks, I think BMO is having mass layoffs. It seems to be a big topic, and so I'm getting a lot of calls about that. I think with respect to these mass layoffs, the number one important thing to keep in mind is obviously the issue of your severance, right? Everybody needs a financial buffer, especially in this context, because you're kind of competing against a lot of other people that have been laid off for new jobs, right? And so, if you feel like something's off with your severance package, if it doesn't seem like it's enough, if you've been with a company for 30, 40 years and they're offering you a few months of severance, get that package reviewed, because it could make a big difference, right? A few months of severance and, potentially 1 or 2 years of severance pay. We've got our first question here from Tony. Tony's asking, what is the proper amount for someone saying working for 10 years at a place in Alberta? Yeah, Tony, that's a good question. There's the length of service you've mentioned. 10 years is an important factor. Anybody that regularly watches these shows or my shows will know that there's a lot of factors that go into determining severance. Okay? Length of service is a big one. How old you are, so your age, is also a big one. If you're 65 years old, you're at the end of your career, you're nearing retirement, you should be getting more severance than someone who's in their 20s, right? It's because someone in their 20s, presumably it's easier for them to find a job than someone in their 60s. There's that stigma, right? Your position also matters. If you're a vice president of a company, you usually get more than someone who's kind of lower down on the ladder, right? Someone who's maybe, say, a junior analyst or somebody's working on an assembly line. So your position matters a lot. And those are the three big ones: your age, your position, your length of service. There's other ones that sometimes come into play. There are cases where, if you're medically not well the time you're terminated, courts have found that you should be getting more severance than otherwise. If it's a bad job market, right? So mass layoffs, the economy's not doing well. There's not a lot of jobs out there for you to try to, apply to and secure. That's also a factor. There's probably 10, 20, 30 other factors at least that could come into play depending on your situation, right? So Tony, to your question, someone that's been there 10 years, it depends how old they are, depends what their position is, but it could range for anywhere from, let's say, 6 months at the low end, and someone with 10 years, I've seen some of them get upwards of 18 or 20 months, right? So you're saying 55 years old. Let me know what this person did. as a living, and maybe I can give you a better range. Hello to you too, Boloof, I think your name is. Trevor's asking, can my employer hold on to my vacation pay from last year, and how do I ensure it is provided to me? Yeah, Trevor. So vacation pay, it's regulated provincially generally. Some employees are covered under the Canada Labor Code, but each province has their own what's called employment standards legislation. It's different. It varies from province to province, but in general, if you don't use vacation that you've earned in a certain year, it's paid out to you, right? So if you had 4 weeks a year, and you only used 3 weeks, you only took 3 weeks of vacation that year, that one extra week should be paid out to you, right? Um, in cases where you're terminated from your employment, or even if you resign, at the time you're terminated, if you haven't used, if you have a vacation pay you haven't used, at least in BC, that's considered wages, right? And that actually has to pay it out to you technically within 2 days of when you're terminated. So to your question, the answer is probably no. They can't just hold on to it. I would ask them why they're holding on to the vacation pay, and to ensure it's provided to you, see what their reasoning is. I doubt it's permitted, depending on where you are in Canada. And then if you have to, you can file a complaint with your provincial employment standards branch. So in BC, that's the BC Employment Standards Board. Okay. Got a question here from Carol. So Carol, you applied to a position, you got the job. Once you started, it was a different position. You were told this is only temporary as they had an abrupt departure. The role you're doing now is not one that you signed up for, but you just started and you're worried about being unemployed again so quickly. Yeah, Carol, there's a few different things you could do there. So depending on how long this temporary thing lasts, if it's a matter of a few days, I would say if you're just covering for someone for a few days, it's different than if you've been in the job for a year, right? But there is something called a constructive dismissal of your employment, and that's just a legal term for the employer changing your job in a fundamental way, where the law permits you to quit and claim for severance, right? And that just doesn't apply to your job responsibilities. That applies to, if they cut your wages, they cut your hours, they change your compensation structure drastically. There's a lot of different ways an employer can change someone's job significantly. So in your case, if you applied for a manager position and then it turns out it's kind of they put you in a cashier position, that's clearly a constructive dismissal, right? So in that case, you would be entitled to say that this is not what I was hired for. My contract says this, you're giving me these responsibilities, and you have the option, you don't have to, but you have the option of resigning and claiming for severance. And hopefully that severance allows you to cover yourself financially until you find a new job. I think, depending on how many hours you've accumulated, that could be a case where you could claim for EI as well. Under EI legislation, I think it's called a resignation for cause. So that's another potential, potential benefit you could look into. And at least in BC, I know that there is something under the Employment Standards Act where an employer cannot misrepresent the position and the employment they're hiring into, right? So if that's the case, you could also file a complaint with the Employment Standards Board. And so you have different options there. So I think the first question that I have is, what's temporary, right? Was it a few days, or have you been doing this for 6 months now, right? Okay, so Tony, you're following up on your question. So you're someone. So we're talking about a situation. You correct me if I'm wrong, but they've been there 10 years. They're 55 years old, and they work as a welding supervisor. I mean, in that case, Tony, I've seen cases, 8, 10, 12, maybe as high as 14 months for that situation. I think that's, I can't give you an exact off the top of my head, but I think that's the range, right? You assume maybe 10 to 14 months for someone in that position. And part of that, Tony, is one of the factors that that's kind of critical is how long it takes someone to find comparable employment, right? So if you've been let go, um, let's say today, and you find a job in 2 months, right? And that job is kind of pays you the same, similar benefits, similar compensation. Arguably, your severance is limited to that 2 month period, right? So that's a big factor that you should know. But if you don't find a job for 8, 10, 12 months, I think that's kind of the range, right? Of how much severance someone in that position should be getting, subject to how long it takes them to actually find a job. One of the other big factors that I missed is it depends on the terms of your employment contract as well. Um, a lot of employment contracts that I've seen, they don't actually talk about termination, right? And so they're dictated by judges, common law. That's the range I'm giving you. But if your employment contract says if we let you go, you'll get 4 months notice, right? Then your severance might be limited to that 4 month period. Um, the contract might actually not be enforceable. So that's another issue. If it's not enforceable, you could get more. All of that to say is I'm kind of giving you some general answers here, but to get a well-informed answer, you've got to seek legal advice on that, on the specific situation that you're dealing with, right? Because there's a lot of factors that we can't really get into on here, but some of them you'll need to actually show the lawyer your employment contract if there is one, and talk about kind of the background of your termination, why it happened. You know, did they terminate you with respect, or were they kind of acting harshly, right, during the termination process? There's a host of different facts that matter when dealing with a termination. But hopefully that's a helpful general answer. You can feel free to follow up, and for anybody else, can feel free to follow up on anything I say, and then hopefully I'll be able to get to you. Okay, we've got more questions here. Got a question here from Edward. You were recently let go, and you were told that they didn't need your position anymore. You're suspecting that it actually was because you took a sick leave for 3 months when you had to be in the hospital. You're given a hard time upon your return. You were offered 3 months in severance. What are your options? Okay. So Edward, it's unfortunately, from my perspective, that's not uncommon. It goes something like this. An employee, long time employee, works for, let's say, 5 years. They go on a medical leave for a few months, or sometimes upwards of a year. A year later, they try to come back to work, and the employer, instead of letting them come back, just terminates their employment, right? There's In a lot of those cases, I would say there are things to be suspect about, right? Because as hopefully most of you are, know or are aware of, we have human rights legislation in BC, right, and the rest of the provinces in Canada. And what that legislation says is you can't discriminate against anybody on the basis of their disability. When someone's on a long medical leave, it's probably because they have, some sort of permanent or temporary disability that prevents them from doing their job, right? And so if your disability or your medical leave, if that was a factor, right? Just if that was a reason that the company decided to let you go, that's considered illegal and against human rights legislation in BC, or the rest of Canada. So in terms of your situation, I mean, it's something that to look into. And some of the stuff to look into is, did they replace you with anybody, right? Did they eliminate the position, or did they just replace you with somebody and give them a different title, but they're actually just doing your job, right? That would kind of be strong evidence of discrimination. So your options are, well, number one, severance, right? You were off for 3 months, but depending on your age, and simply because you are coming off medical leave where you're probably not 100% yet, your severance should be longer. As I referred to earlier, your severance should be longer if you're medically unwell at the time of termination. Your second option is obviously a human rights complaint to the tribunal, to the appropriate tribunal, and that tribunal can award. They can go as far as reinstating you to your job if they find discrimination against the company, right? There's other remedies for what's called injury to dignity damages. So that's to compensate you for the discrimination you've had to suffer. And they can also award any lost wages that you've had to suffer because they let you go. You say you were given a hard time upon your return. I'd be curious to know, how did the employer correspond with you? What did they do to give you a hard time? Because they do have a duty to accommodate you, right? They have a duty to accommodate anybody with a disability, and that could mean putting your job down to part time, from full time to part time, maybe removing some of the tasks you can't do in your job, maybe getting someone to help you with some other tasks. So I think, Edward, there's a lot going on in your situation, and I would suggest you seek legal advice, and maybe try to find out what happened with your position, right? Because that's going to be some evidence of whether there was discrimination or not. Okay, I've got more questions here from Bolative. Sorry, I can't say that word. So you're currently on short-term disability. You've been off work since April 23. Your short-term was denied, and your employer sent an email to return to work on Tuesday. You're not comfortable going back to work yet. How do you respond to the email to the employer? Yes, so I will say this for the short-term disability and long-term disability benefits. Just because you're denied doesn't mean you have, that you don't have a disability, right? Those insurance claims, in my experience, are denied, quite frequently when they should not have been denied. So in terms of how you deal with the company, I suspect they're going to ask you whether you intend on appealing or not, right? And they would want some documentation substantiating that you're still unable to work. So I would respond, and again, I think, come talk to me if you're in BC, or one of my colleagues if you're in another province, but I think the appropriate response would be, if you're not ready to go back to work, you tell them you're not medically cleared to return yet, right? And you're going to get, and they might ask for a doctor's note, right? They might ask for a doctor's note, in which case you go to your doctor, you get a note saying, my patient's not ready to come back to work yet, right? He'll be reassessed in X amount of time. And so that's how you should generally respond. If you're in BC, please feel free to message me or call me afterwards, or we can chat about this more. But if you're not ready to go back to work, you get a note from your doctor. Your employer will want to see that to let you stay on medical leave for a bit longer. In terms of the short-term disability, I mean, I think we can talk more about that privately, Balativ. I need to see all the details, but that's something, if you did appeal, which I think you're saying you did, and you've been denied again, and your doctor's telling you can't return to work yet, right? Come talk to me. We can talk about it. The next step might have to be a lawsuit against the insurance company. And so in the lawsuit, what you would claim for is reinstatement or approval of your benefits, and then they'll start paying you weekly or monthly again. Again, we can talk about that privately. You don't have to go into all the details here of your situation in this public forum. But I think for now, you tell your employer you're not ready to go back, right? And then if they want a doctor's note, fine, go get it. And then in terms of the insurance claim, you can, if you have a doctor that's supporting you, and if you feel you cannot go back to work right now, come talk to me, and we can talk about a potential litigation against the insurance company to get them to kind of change their mind. Okay, I got another question here from Greg. You've been doing marketing and promotion for a company for almost 10 years. Owner decided to sell, and your employment's going to be terminated. You were never given a written employment contract. Are you still owed anything? Yeah, Greg, that's a good question. So I guess short answer is yes, you are. The long answer is it's probably there's going to be a question of who owes you termination pay, right? Whether the previous owner or the new owner. And that depends on when your employment is terminated. But just because you don't have a written employment contract doesn't mean you don't get severance, okay? In fact, if you don't have a written employment contract, that's probably better for your severance pay than if you had one. Because if you don't have one, it's governed by common law, which means that judges will determine what severance you should get. And so all that stuff I talked about before, your age, length of service, your position, that's what goes into determining your severance. So, yes, you are owed severance pay. It's just a question of how much. And the other question is, who has to pay, right? The new owner or the previous owner? And to answer that question, we need to go in more in depth about your situation. Okay, so yeah, Balatif, yeah, come talk to me or one of my colleagues, depending on what province you're in. You should just be able to see my contact on the screen, or maybe just Google my name and Samfiru Tumarkin, and then just give me a call. We can chat further privately. Got a question from Rara. You were one of the ones terminated because you did not comply with taking the vaccine. You were a part-time PSW at a hospital in Scarborough. QP has no answers for me. What is my next step? Yeah, I think I've dealt with this issue in BC a lot, actually. I'm not actually, because I practice in BC and Ontario. I'm not actually sure of all the regulations and legislation regarding the vaccine in Ontario. In BC, certain workers have to be vaccinated, right? Certain healthcare workers have to be vaccinated. I think it's similar in Ontario. But the biggest issue in your situation, Roz, is I think because you're unionized, under QP, presumably, I can't actually help you with the situation. You'll have to go to QP and the union rep because they'll have their own lawyers that can help you. I'm sorry to hear they haven't had any answers for you yet. But because you were unionized, you'll have to go through your union, unfortunately. And I'm just not that familiar with the vaccine landscape in Ontario. Okay. Tony, you're asking if I'm affiliated with anybody in Edmonton, Alberta. So yeah, we do have an office in Calgary, Tony. So they take on work from all over Alberta. So if you want to give our Calgary office a call, if you need anything, or our intake team, they can set you up with one of my colleagues at that office. Okay, I've got a question. Just want to say thank you from Canadian Homestead. You were let go for not wearing a mask. Union threw you under the bus. No lawyer. There was no lawyer because the union was involved. Had to represent yourself. You won your human rights case. Good. Can only say legally we settled. So no problem. I'm glad to hear it. Tony has got a question. Can employers say accommodation is no longer suitable? So Tony, I assume you're asking the context of, you have, or somebody has a medical issue and they need accommodation at work. Hopefully that's what you're asking. If it's not, you can just let me know in the comments there. I would say generally the answer to that question is no. An employer has a duty to accommodate a disabled employee, whether that's mental health or something physical, up to the point of undue hardship, right? So what is undue hardship? It's a legal term that's been defined through probably hundreds of cases, if not thousands, of what it means. And one big thing is financial cost to the company, right? If it's going to cost the company $1 million a year, let's say a small business, $1 million a year to accommodate you, I'm over exaggerating, but let's just say that's the case. Then that's probably undue hardship, right? If a small business that's only making $100,000 a year has to pay all this money to accommodate an employee, that might be undue hardship. If it's a big company, multinational corporation, Fortune 500, it's harder for them to say it's financial reasons that they can't accommodate you, right? So there's a lot of different things I need to know, like, what's the accommodation they're giving you, what's the nature of your disability, and what are they helping you with, right? If your question is that they've been accommodating you for the last little while and now they're saying we can't do it anymore, I guess the question to put to the company is why not? What's changed, right? So I think my general answer to you, Tonia, is no. They can't just simply say that it's no longer suitable. The accommodation is no longer suitable. There's a question that has to be asked to them of why, right? Like why is it no longer suitable? What's changed in the situation? Because if they're accommodating you before, then something must have changed. That they're saying it's no longer suitable. And so I think you need to ask that question, and then you need to kind of judge their response and kind of the whether it's credible, whether it's believable, and if your spider senses go off, if it doesn't sound right, go talk to an employment lawyer. Come talk to me if you're in BC, because if they're not giving you a reasonable explanation, the next step you would do is file a complaint to the Human Rights Tribunal, right? And you would say to the tribunal, the employer's been accommodating me. They're saying they can't do it anymore, and they're giving me this explanation which doesn't seem reasonable. And then the tribunal can help compel the company to keep accommodating you, right? That's what they're there for. Okay. Got a question here from Helen 2006. Helen's asking, does the Supreme Court have a lot of retaliation cases? How much extra compensation can you get? Yeah, so Helen, that's a good question. The Supreme Court of BC deals with some retaliation cases. I would say a lot of them are in the Human Rights Tribunal or WorkSafe BC. Obviously, it depends on what retaliation we're talking about, right? Like if you're raising a workplace safety issue, right? And then you raise it to your manager, and then the next day you're let go. That probably goes to WorkSafe BC, right, for retaliation. In terms of compensation, you'll get they can award your lost wages. They might be able to get your job back. You might get reinstated. If you're raising discrimination at work and you're telling the employer, I'm going to file a human rights complaint against you, and then a few days later they let you go, that's probably retaliation that goes to the Human Rights Tribunal, right? And depending on some people are provincially regulated, some people are federally regulated, so there's different places you go depending on what legislation covers you. In terms of the Supreme Court, the retaliation comes mostly from what's called extra contractual damages. So punitive damages, aggravated damages. If a court finds that there was retaliation for you raising legitimate concerns with maybe some ethical practices or borderline illegal stuff, or even if you raise things the company are doing illegally, right? You're a whistleblower. There is extra compensation a court may award you, because if they find that you were fired because of you raising these issues. Whether they have a lot, I can't say. A lot of cases settle and they never get to trial, so we don't know about those cases. But from my perspective, there is certainly some cases that in the Supreme Court. Okay, so guys, I think that's all the questions. Hopefully, I got to everybody today. If I've missed anything, my colleagues will be on tomorrow and next week. I'll be back on probably in a few weeks. I hope everybody has a great. I got one more here. So Tonya, you're saying after you were accommodated for a while, you were asked to bring in all medical information. They said they have to review it again. Does that sound right? So I think, Tony, in general, right, they have a right to some medical information. Okay, they in general they can ask for prognosis. They can ask for your restrictions and limitations. They cannot ask for your diagnosis. Okay, so there's some general rules there. I would take this, so if they're asking for prognosis, restrictions, limitations, that should be fine. If they're asking for your full medical records and where your diagnosis is and all the details of your condition, that might not be okay under the law. So just keep that in mind. But yeah, that's all the time we have for today. Tony, if you want to reach out, whatever province you're in, reach out to one of our lawyers if you're, if they do decide to stop accommodating you, and we can help you out. But yeah, so I'll end it there. I hope everybody has a good weekend, and I'll see everybody in a few weeks.